Sometimes you may feel that you are trying to explain the other party what they merely do is not legal. A divorce or legal separation judgment is not a mere recommendation. It's a binding decision and has effects on both parties. It's a binding court order. The reason that I'm recording this video is because we represented a client in this matter, and I see, although this is something that overlooked sometimes, this is seen as not as important as the other topics. This is still important to keep in mind because disputes can arise even after the court order, even after the decision was made by the court. If one party fails to comply with the court order after separation or divorce, we generally start by sending a formal demand letter. A letter from a legal counsel can be a game changer because sometimes people do not understand the seriousness of the issue unless they receive an official letter confirming the violation from an attorney. Sometimes you may feel that you are trying to explain the other party what they merely do is not legal. If there is a court order, and with divorce or legal separation, the courts usually order for judgment regarding the property division, let's say. If the court decides to divide a community property, or if they say the husband will have the car, whereas the wife will have the home. However, even after the decision, let's say the husband does not comply with transferring the title of the home. Or another example, let's say the both parties are living in the same home with lease. So they're not the homeowners in that scenario, but they rented the house together during their marriage time. But then they divorced. And as a matter of divorce, the court decided that the husband will stay in the house. He will be the only tenant and he should release the wife's name from the lease agreement. However, the wife can come and says that the husband does not inform the landlord that they divorced, so the wife should not be on the lease agreement anymore. And the wife doesn't want to be liable for the debts of her ex-husband related to that house just because her name was on the lease agreement once then they were married. So according to the court order, what should the husband do? He should notify the property manager that he is the sole tenant right now. Our client's husband didn't do this. So what we do, we send a formal demand letter to the husband. And we also inform the property manager, the landlord. Of course, they are not a party to the family relationship, to the order of the family court, so they are not automatically obliged to release her. However, they should be requested by the responsible party, which is husband in that case. So what we do in that situation, we send the demand letter to the non-complying party. And as I say, most of the other parties, most of our opposing parties comply with their orders when they receive demand letter from our law firm because they understand how serious it is after that stage. However, even if they do not comply, although they receive a letter from us, mediation could be appropriate if the judgment or their settlement agreement when they divorce, which we call marital settlement agreement, contains a specific mediation clause. Or if mediation is not provided in the agreement or is not successful, then we can go to the same family court and file request for order, asking the judge to enforce the existing court order.